this matter, just before the vacation, my lord. Lordship allowed him visiting my lord. My lord, I did not come. It was about the regular. The vacation time, the I did not come. You not allowed me. It is not having regular court before your lordship.
So it will come. What order has to be passed?
My lordship, I have to go. Matter was this is
I'll get the file. It is a restoration. Then list it on Wednesday, Monday. Monday list it.
assigned matter group 7.
Inclusion, give monthly list, it will come.
But I'm mentioning for upgradation, my lord. The matter has been mentioned before vacation, and your lordship please to fix it after vacation, my lord. But urgency is that, my lord, the mediclaim expenses amount of the petitioner has been withheld only on the ground that the prior permission has not been taken, and this is the only ground for which the
We
entire
have taken up this matter.
Yes, my lord. This matter has been
Then-
taken by your lordship, and the matter is part heard. But
Not
it is-
part heard. No matter is part heard. We
Prior-
don't have any part heard matter on the list.
My lord, I beseech to your lordship, but the matter has already been taken by your lordship. But
That doesn't make it part heard. Don't say part heard.
Yes.
Part heard, you know what it means.
yes, my lord.
Yes.
Your lordship kindly fix it any day, my lord.
Sorry, it will come. We have heard it once, it will come.
And
You wait
another
for some time.
application, my lord, the contempt application where the direction has been passed by your lordship upon the contempt not to disburse the salary amount of the petitioner, but the salary amount has not yet been disbursed, my lord.
What is the date of the order?
The order has been passed in April, my lord. 2025.
How much time was granted?
My lord, on and from the next month from the order, my lord.
Give it, it will come in the next week.
Great.
Monday week.
Great, my lord.
Yes.
My lord, your petitioner did not receive the certified copy of the judgment. Judgment passed on 24th September 2025. Till date, my lord, I filed an application for certified copy. of the
Why it
judgment.
has not been
For
made
this
available?
purpose, my lord, I am mentioning this matter, and
Tell him.
your lordship, your
Just tell him.
petitioner filed an application in Supreme Court for the judgment of Honorable Court. So, my lord, may kindly direct the court concerning officer, court officer, or concerning staff to send the file immediately.
They are saying that it will go.
Send the certified copy of the judgment, and your lordship
All right.
pass an order, your lordship found fit and proper.
All right.
Item number 1.
Which proceeding? Come for that. Can 1. That is already allowed. Okay. Also, these two orders have to be corrected. Order of 10th June and order of 11th August has to be corrected. That is already corrected. What time would it is? Yes. Only these two orders. Two orders have to be corrected.
My lord, in similar and identical matters, your lordship passed the order where there is a shortfall of more than 5 years, my lord, on the same and identical
has been
question.
Placed today.
No, modified. হয়ে গেছে করে দিয়েছে
Also, my lord, in a similar and identical question, my lord, I argued the matter, your lordship was pleased to pass the order in Hirelal Ghosh, my lord.
All the best.
It's very celebrated judgment.
item number 2
I am for the respondent. I have been engaged yesterday and yesterday at 5 p.m. I received the brief. I have not gone through it and neither have received an instruction. I want 2 days time to go through the brief and take instruction from the department.
My lord, can the section 5 be disposed of meanwhile?
Section 5 has been filed.
Yes,
What is the CAN number?
can one.
It's not here. Section 5 has been filed.
Yes, my lord.
Why? It is, where is the limitation to be condoned?
There is a delay of more than a month.
Delay from which date? What is the date on which limitation lapsed?
My lord, the order date was 12 February 2025 and I received the certified copy on 23rd April 2025 from
The order is dated
12
12 to
February.
25.
Yes,
So it was to be challenged by which date?
3 months to that, my lord.
Where is that provision? Show us. Where is that provision requiring the challenge of an order in a writ proceedings within 3 months? Which provision of the Limitation Act?
Section 5, my lord. Not the Limitation Act, but then condonation of delay was filed by. It is section.
Condonation of delay is filed when it is filed, when there is a delay. When there is a delay, when the filing is beyond the period of limitation is specified in a statute, rule, or any provision.
Yes, ma'am.
So where is the statute, rule, or provision which is specified that writ petition has to be filed within 3 months?
Challenging the order, ma'am.
Huh? Where is the can? Where is can 1? You file your, you take instructions. By when?
Can you fix it on Friday or next week?
Next.
Next week.
The filing
Learned
section.
advocate. For writ petition.
Yes, ma'am.
They call us, you have to file it, otherwise I will not take the filing. They does this thing. This happens with also with me. Then you have to take an leave from the court, then I will
My
allow.
lord, the dispute itself went on for 12 days in the filing section.
Filing section does this thing. They will not give a written note. You take a leave from the court.
Can 1 is dismissed as not present. There is no provision, there is no limitation for filing a writ petition. Therefore, there is no question of filing. It is governed by the principle of delay and latches, not limitation. We'll see when it is taken.
7th November.
7th November.
7th November. I'm deeply updated.
7th November. Item number 3.
Affidavit of service.
ওই কারো আমি শ্রী তো রমন কুমার পাঠক আমি প্রমাণ করতে পারি right now I'm taking বলো 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 Lord, I appear for the respondent. My client has received the copy of the petition, but it has not been handed over to me. Lord, any other day, my lord may take it up instead of today. পড়ছে বুঝলে ওটা কত বল কিন্তু ওটা পড়ছে নাই 28
Logo is right. Right. Okay, answer. Right.
Yes, what is wrong with the order?
My lord, there is no scope of alternative post.
There is no-
Kindly see page 31. There is no scope, my lord. It's a purely contractual basis labor.
That's not the point. The point is there is an order of 3/12/19.
Yes, my lord.
There is an order of 3/12/19. That order has to be given effect to.
My lord, 31st December 2019.
Yes,
কত আছে? কত?
on 10/6/2019, OA was disposed of 271 of 2013.
Yes, my lord, page 18. My lord, kindly see.
Page 80.
My lord, shall consider. My lord, we have to consider and we reject it. We shall consider and reject it.
So where is the reject?
Annexure P2. Can you see, my lord, annexure P2?
P2.
P2. Page 22.
Page
22. My lord, for your kind information, last two line, my lord. Under the circumstances as per the condition laid down in the policy, it does not seem feasible to impose upon any officer to consider your appointment as sub-bungalow peon attached to his post because an officer is entitled to propose the candidature for a person of his own choice. Therefore, it is not feasible to appoint a sub-bungalow peon under of your officer.
What is the traffic? Or not? So they say it cannot be. Yes, what is wrong?
My lord, your lordship, I'm without brief today, my lord. Your lordship, kindly take it up any other day subject to a lordship sanction.
Let my lord let petition be admitted.
Any other
And
day
it-
subject to.
Mr.
Tenth November. 10th November. Affidavit of service may be given.
Affidavit of service be kept on record. Let them file opposition in the meantime.
Affidavit of service kept. No need for any opposition. We'll hear it.
If they require.
Not required.
Top of the list.
Grateful to your lordship.
Grateful.
Item 4.
We have got the respondents. Because the applicant, what opposition you will take?
Paying for expeditious hearing of the matter pending before the Central Administrative Service. Matter was filed 2019, Mala. 32 times matter appeared, but till date matter has not yet been.
So what is your urgency?
Urgency malad petitioner before lordship malad he appeared for the post of
We are not asking the history. We are asking what is your urgency.
painting matter.
So therefore, so you are for Union of India, sir.
No matter. Union not matter.
No, it is by the petitioner. But you have been taking time. You see the record.
Most of the time respondent taking time.
No, sir. The records suggest otherwise. You are making corrections for up to more than 1 year after filing of the OA. And thereafter, there are 2 dates on which, with consent of both the sides, the matter has been adjourned. And you are standing before us that the direction should be given for.
Page number 9.
Sorry, we are not. We don't encourage such things.
Order dated 13 December 2022.
No, we are not required. Not required.
Many times appeared court adjourned that time without hearing. Kindly see
Yes, many times.
many times.
Yes.
Order dated December 13, 2022. Thereafter,
What will happen in this matter now?
December 13, December 13, 2022 till date. No hearing.
December?
Order dated December 13, 2022.
Yes.
Thereafter, no hearing was conducted.
No hearing.
Kindly see. Last but 90. Page number last but 90. 9 last but 90. December 13, 2022. Thereafter, no hearing was conducted. Just fixing that date, one after another.
So it is for hearing. It has been admitted.
Admitted and hearing fixed. Thereafter, nothing has been
Huh?
done.
Yes.
These were complete on December 13, 2022. On that date, it was treated to have been admitted. And another point, my lord, kindly consider it. Such supervisory power of the Honorable High Court is vested under Article 227 of the Constitution of India over the lower judiciary. He is praying for an order upon the learned Central Administrative Tribunal. The application is under Article 226.
You go and pray. You go and mention the matter before the tribunal. Go and mention. Or the counsel for the petitioner and the
Item number 5.
Item in this matter, Miller Surya Sarati Basu, who expired on 26th September, Miller. Surya Sarati Basu. In this matter, Miller, he expired on 26th September. Let this matter be taken up Monday, Miller. Take appropriate step. Oh, 29th September, Miller. Yes.
Yes.
29th September.
The matter to be listed. As per list on Monday week 10. They will all be adjourned. How you are appearing then? How we can record a prayer if nobody is appearing? You tell us.
Because Miller, the
None appears. Let the matter come up after 2 weeks. Yes. Very well.
Item number 6.
6, 7, 8 Miller item and one matter left out. That is not a 4 matter they have 5. 3 has come.
So let us take up 6.
I am saying Miller, some accommodation let it be taken off Friday.
Why, sir?
I kindly Miller. Identical matter Miller, 6, 7, 8 and 1 more.
Let us see.
I'm asking for it.
और 7-8 तो इन्होंने फिल किया
6, 7, 8 as prayed. List after 2 weeks.
তো 22টা ওর সঙ্গে আসবে হ্যাঁ হ্যাঁ 6, 7, 8 6, 7, 8 তাহলে ওইগুলো 11 3 weeks বললো 5টা থেকে শুরু করবি 5টা থেকে 18টা আগে 18 দিলে হ্যাঁ item number 9.
Yes.
They are based for the. I do not observe that the primary route of promotion to the book to the applicant been unsatisfactory reduction of the past 5 years. HCR 6 years. In fact, the applicant has consistently respond because here and computation last time I was entitled to get promotion in the year 2017 to the post of chief engineer as per garrison. That was not awarded in favor of. I made application, no response. And now I came to the tribunal. Because the tribunal, after filing the affidavit by the state respondent, I got the information that due to unsatisfactory execution of HCR, I was not given that promotion. It was not within the knowledge of the applicant prior to filing the affidavit to the tribunal by the state authority. And my lord knows the very well proposition of law that in case of any unsatisfactory evolution of HCR, communication is required. No communication was made. I took that point in my affidavit to the tribunal as well as to your lordship. So, if the no communication was made regarding the any entry, at least 8 entries are there, and any entry which is unsatisfactory or which is below rank, below mark, grade mark, communication is required as per the law settled by the honorable appellate. May I be allowed to place the one judgment in that regard, my lord?
So that promotion order of 17 you challenge.
Right.
By which way?
By original application before the tribunal.
When?
That was challenged, my lord. Initially, my lord, the tribunal the limitation part, my lord, that was over.
Sir, in May 2017, you were not promoted as chief engineer. They say you are not promoted because the last 5-year ACR was not up to mark. Again, in May 22, you are not promoted as chief engineer. This time they say that there is a proceeding pending against you. Now you say the 17 promotion was denied on the basis of ACR entries which was never communicated to you. So you must have challenged that promotion order of 2017 that I have been left out wrongly.
By one original application of 411 of 2020.
In 22,
22.
after the second promotion order.
After the third or fourth promotion.
No, sir, your case is only 2 promotions, one of 17 and one of 22. 17 you have been deprived because there was adverse entries, 22 you have been deprived because there was a proceeding pending against you.
Kindly allow me to clarify that, please. On 25th May 2017, the first time, 3 persons superseded.
That is precisely what we are saying. What is there to clarify?
Thereafter,
And thereafter in 7/5/22 again you have been.
thereafter 29/6/2017 again. Thereafter 4/7/2018 again. Thereafter.
So none of these orders you have challenged.
In the
Where is? Show us. Where have you challenged?
it was continuing, my lord. It was continuing.
What continuing? All these orders are separate.
Page 53.
What do you mean continuing? Just by saying continuing, it does not become continuing.
Superseding, my lord. Continuous superseding.
So let them supersede 50 times.
10 to 12 times.
Therefore, you are sitting idle.
No, my lord, I made application before the authority.
Keep making applications. Make more application before the authorities.
Page 53. Thereafter, again, in my affidavit, page 85. Page 85 also, my lord, para 30. And in regarding my lord departmental proceeding, the evaluation of for ACR for past 5 years. If I was entitled to get the promotion on 2017, then last 5 years will be counted. But the departmental proceeding is initiated on 2021. So the departmental proceeding no related with my earlier promotion. And for the next promotion, that is engineering chief, the department cancel the entire departmental proceeding. Page 93 minus. So the departmental proceeding also not a bar. My humble submission with your lordship, subject to my lord, kind of filtration. Entire departmental proceeding was cancelled. So my humble submission with your lordship. Now the departmental proceeding is not a bar to give the promotion for next part. That is engineering chief. Lost the habit, my lord. Due to long vacation, lost the habit.
So he is not operating properly.
Due to 1 month vacation, that happened. My lord, my humble submission, first one, in respect of communication of any adverse noting as per the Honorable Apex Court mandate, it is mandatory. And if the question will come regarding the departmental proceeding, that is now no existence. That has got no existence now.
My lord, may I place one authority, my lord? That statement shows that statement in your reply to the tribunal that the ACR was not communicated. Yeah, the first time. Again, we are asking you, where have you said that ACR was not communicated? Page 83. Yes, read where it says that ACR entry was not communicated. Yes, page 83. Please read. Page 83, para 10. With reference to the statement made in para 6.10 of the evidence in opposition reply, I deny each and every contention and or allegation. 7 except which a matter of record, and I further submit that the applicant has been serving this department daily devotionally with his promotional right accrued with effect from 20 May 2017. But the establishment illegally deprived him to take the promotional post without giving any reason and without observing operation of condition of service, harassing the applicant from getting the if no notice was served upon the applicant at any point of time in adverse of any remark of any point of ACR, APR or ACR from the PWD, therefore question of unsatisfactory execution is an emergent product of the respondent. Yes, very good. So you did not challenge the order of promotion. Challenge my in my opposition, my lord, affidavit. You are still in service. When did you retire? Get a check. Retired. Page 85, my lord, challenge that. I consider para 30, page 85, para 30. No, you did not challenge. You didn't challenge in 17, you didn't challenge in 18, you didn't challenge in 19, you didn't challenge in 20, you didn't challenge in 21. In 22, when the second time promotion it was given to him, then you have challenged the 2017 order because you know 22 you cannot get because pendency of departmental proceeding. 22, if I not get the promotional benefit, my lord, that is in respect of next promotional, that is engineering chief. But the my immediate promotion. How you can go to the next unless you go to the first, how you can go to the next? That is why, my lord, you cannot go. I have challenged 2017 in my original application. Thereafter, in my affidavit, my lord, I have challenged.
all the promotional notification. 25th May 2017, but kindly allow this the relevant paragraph. Therefore, under the applicable factor circumstance, Lordship may necessarily please to pass and allow the player already made application and
Where is the promotional order of engineer in chief of 22?
yes,
Where is that?
but it's
Page 87. This is engineer in chief.
no, it is chief engineer.
This, sir.
Engineer in chief. That is page 88.
This you have not challenged. This you have not challenged.
This one.
You,
And until I get the promotion of chief engineer, I will not.
what is this? You please first get in your mind what is your case.
Right.
We said in 17 you have not challenged the promotion of chief engineer. You have challenged it when next promotion of chief engineer was done in 17. You said no, in 17 engineer in chief promotion was done, which I have been aggrieved by. But you have challenged the order of 7/5/22, which is promotion to chief engineer. It is not engineer in chief.
Yes, ma'am.
So therefore your submission was incorrect.
Both I have challenged.
No, you have not. Show from your prayer. Come to page 53.
May 2017.
That is all.
And thereafter, page 85.
What is this? You are making all kinds of submissions contrary to the
And
record.
85, page 85,
What 85?
page 85, para 13.
Para 13.
All notifications.
So
I
in
have
reply, you will say that quash all the notifications. That is the way. Show us from the administrative tribunal rules that this is permissible. Very unique submissions you are making. We will have to learn many things today from you.
But
The thing is, you are challenging a promotion of 25/5/2017 by filing OA in 22.
Right.
That is the only thing. There is nothing else here.
that part, my lord, before the tribunal, I filed an application for condonation of deal. That was condoned. That is the part.
Yes. You filed a condonation of delay. Where is the condonation? Where have you said in the writ petition that you filed a everything you are saying contrary to record, unique submissions you are making continuously. Not awarded. How do you know? No time whatsoever.
But the right, but the main.
Sir, you have not, either you have not gone through the brief, either you have not read the brief, unfortunately, or if you have read, then it is more unfortunate that you are making such submission.
Regarding non-communication of Asia.
All right, that you have already said, don't repeat that. And 22 promotion you have not challenged. Now you want from 2017 by filing an OA in 22. And you are saying condonation has been filed, there is no pleading. You say 22 has been challenged, not challenged. Everything incorrect. This is not the way.
Kindly give me some accommodation.
I'm sorry, no accommodation. For what accommodation? What will you do? Then you will read. What is this? Wasting the time of the court. Yes.
Page 64, my lord, what has fallen from his lordship, my lord. He has written for the first time, my lord, with regard to the letter that, my lord, non-granting of promotion in favor of my client to the post of chief engineer with effect from 25/5/2017.
Yes.
First time it has been disclosed in 2022 by way of this letter.
So that is the first objection raised.
First objection he have raised. Thereafter, yes, after that, well, he filed the application. He has made aspersion against one officer, Bhaskar Ghosh. Lord, from the above, realize that my client has been suffering tremendously due to the whimsical and autocratic attitude of Chief Engineer, North Zone PWD from the Gates. He knows everything, my lord. He has made aspersion against one officer, my lord. He don't know that his ACR has been, there is some defect in his ACR or some marks in the ACR. Hence, you are requested to please look into the matter so that my client get promotion to the post of Chief Engineer with effect from 25/5/2017 without anything.
Yes, we have. Can the tribunal, you have stated why you have not considered him in the.
And it takes page 71, my lord. 71, paragraph 6 onwards. My lord. Paragraph 6, lordship kindly takes.
No, regarding the 17 promotion process, you have stated at page 73, Roman 8, 6-8.
The applicant though was not in the pertinent or the zone of consideration for the promotion to the post of so and so since 20, but he could not be allowed to be promoted to the post of so and so due to his unsatisfactory evaluation reports on the basis of so and so for last consecutive 5 years, leading to his disqualification for being promoted to the. This is the, and on the basis of this submission, Miller tribunal has proceeded.
No, regarding 22, he has not said anything in the way. Regarding the 22 promotion.
So far, my affidavit is concerned, Lord, I find, Lord, nothing has been dealt with regard to this 22. And not only that, Lord, I have shown to his lordship that letter of the advocate's letter, Lord, wherein lordship will find, Lord, he has confined to 17 only, not 22.
In the OA also, he has,
They also, Lord.
he has not said anything.
And only in affidavit in reply, Lord, in one paragraph, he has said, Lord, with regard to this 22. But prior thereto, nothing has been mentioned.
Kindly give me one accommodation.
Even in paragraph 9
I
also,
can
Lord.
come with the papers, my lord.
What paper?
Regarding confirmation. So far, my knowledge goes.
You will bring some paper which is not referred in the writ petition.
Supplementary affidavit, my lord, in that regard.
Not required. You have not said anything in the writ petition. In the order also, there is no reference of any MA. How you can say that it has been allowed?
Itself, my lord, there is no bar of any limitation.
That is all right. There you are correct. The order, there is no bar. There you are correct. But there is no condonation.
Kindly allow me at least one day so that I can come to the court.
There is the only see if you had stated in the writ petition. If you had stated in the writ petition, no, we are not allowing you liberty to file any supplement.
My knowledge goes, my lord.
Your knowledge how, sir? That is what we are asking you, unless it is stated. You are anticipating that there must be a.
Only one accommodation, my lord. Only one accommodation.
Sorry.
So that I can got the opportunity to play. If that is not available, my lord will take decision. On the next date, my lord will take decision.
Not today. Matter is adjourned after some argument.
Item number 10.
Item number 10, my lord, I appeal for the petitioner. My lord, am I audible, my lord? Am I audible, my lord?
Yes.
My lord, I appeal for the petitioner. Well, the petitioner was a serving doctor who has tendered her resignation. And my lord, she approached the tribunal. The tribunal passed an order for taking a decision on basis of her resignation, which was later turned down on the pretext of shortage of doctors. Where your lordship will find the rejection order at page 62. Same old story, my lord. Your lordship will find page 62.
It was got to be done.
also has been decided by his lordship. I cannot.
No, we understand your situation, but you are not only here to make your submissions.
uh,
Can this be appreciated by anyone that every day we should pass the same order?
because my lord, 12-8 order, my lord, whatever is said, my lord, I cannot say anything with regard to that because that is the order that has been passed.
Now we are thinking how to discourage. Now it is coming to our mind how to discourage this.
Because when this order was passed, and the Advocate General was appearing in the order which has been annexed, my lord, with this writ petition, my lord. The order has been referred to, my lord, at page 64, my lord. His lordship sits with Justice Standard, my lord. Wherein, my lord, I find, my lord, that Advocate General is appearing in that matter, my lord.
So therefore we are saying we may be required to pass some order that it is.
One matter I appear, his lordship has delegated the matter to the authorities concerned with certain directions, my lord, by referring these judgments and all. Still now, my lord, I have never not been communicated with regard to the latest position of this issue.
That was to come up after the holiday.
2 weeks after holiday, it was the order was
What is the date fixed?
coming up in the coming week.
Huh?
In the coming week.
You have the case number.
Right now I cannot, but within half an hour I can give the case numbers.
You come with that case number at 2 p.m. please.
Yes,
You be here at 2 p.m. And if possible, you get the last order also. The last order in that case which we have passed, you can also get it.
my lord, and one matter where you
May be well advised. They may be well advised to give you some instruction in the recess in the meantime.
In the meantime, they will be tried.
How they propose
Let me try.
proceed with the matter.
Yes.
Deeply obliged, my lord. Deeply obliged.
Item number 11.
Lord, I appear on behalf of the petitioner. But before I make my submission, I should submit, my lord, that on instructions, my lord, I submit that the number of petitioners is around, my lord, 50, and court fees has not been paid. I should make this stand very clear because, my lord, if your lordship permits me, I can deposit and then I can.
Deposit. It has to be deposited. Individual court fee. What is the court fee here for the writ petition?
120.
So by what time you will do it? Individual court.
An indulgence.
You are giving the affidavit of service. Taken on record, yes.
It retain its position.
Yes, it will retain its position.
Institute, my lord, I.
At the same position. In the same position.
Item 12.
I am appearing for the state, my lord.
ফাইলটা লাগবে তো অর্ডার পাস নট টাইপ করতে লাগবে না ফাইলটা পাঠিয়ে দিবি না ফাইলে তো পাঠিয়ে না না চেম্বারে পাঠাবো চেম্বার এইখানে পাঠিয়ে তোমার কোনটা সুবিধা বলো এখানে পাঠিয়ে ফাইল অর্ডার শিট ওগুলো সই হোক না আমার লিস্টে আমি দেবো অর্ডার শিটটার পরে কিন্তু অর্ডার সমেত এখানে পাঠিয়ে না না তো সই হয় না পরে প্রবলেম হয় তাই না তার ওখানে অর্ডার ছাড়াই ফাইল চেম্বারে পাঠিয়ে দিই ওটা কি আমরা পরে সই আছে না চেম্বারে ফাইল এখানে ফ্ল্যাগ মেরে পাঠিয়ে ফাইল অর্ডার শিট আছে চেম্বারে কিছু করে অর্ডার শিটটা করে না লাগলে আছে হ্যাঁ কি করে সারাদিন
My lord, I am paying short password, my lord. Again for the statement. But instead of not today, my lord, kindly keep it not this week, my lord.
My lord, I appear for the petitioner, my lord.
I am appearing for the respondent. My pleadings are complete, my lord.
Complete. My lord, impugned order is at page 49 of my application, my lord. Page 49.
Please give us 2 minutes, please.
Give it.
Yes.
Point out in the word, if you not, kindly see the observation of the landed cat in this at page my lord. Paragraph 5. Their observation the reply has been filed by the respondent denying the allegation and alleging that the applicant not become eligible for promotion merely after completing the requisite year of service as because under the rules, but could be promoted only when vacancy occur. Therefore, whenever the vacancy occurred in this case, also is considered and he may be promoted. The applicant was thus promoted in 1997 as sub-inspector. Only point is whether I was entitled to get promoted to the post of sub-inspector in 1992 or not. That is the only condition. They said that at that time I did not complete 10 years, but it was approved by the Latin Commission to take up the case.
Where they have said because of 10 years you have not been done. Where have they said?
That was taken by them.
That is irrelevant. They are saying unless vacancy is there, you can't be done. There is no question of 10-year, 5-year. They say prior to 97 there was no vacancy.
To the post of head constable.
That is over. That was already granted. That issue is over. They withdrew it again. It was reimposed. That is not here. Only sub-inspector. Forget about. That is the only thing. Yes.
They have not said, they have not produced any document.
Where have you said the vacancy was available? Show from the OA. Show from your OA.
That is tribunal application.
Yes. Please show that in 92 vacancy of sub-inspector was available.
That was the award.
Yes.
Page 40.
Yes.
Paragraph 3.
3. Yes.
Thereafter, I submitted another application dated such and such that out of two posts of head constable, what is reserved for scheduled candidate and I was there.
Sir, we are not on head constable. Don't try to mix the two issues. You are claiming sub-inspector with effect from 92, where you have said that sub-inspector vacancy was available in 92. Show us.
On 95.
Huh?
He got that post on 95.
97.
97.
Yes, please. Please show us where you have said that vacancy was there.
And this is my reply at page 4. Page 4, paragraph 12. My reply.
Again, we are asking you, where have you said before the tribunal that in 92 post was available for sub-inspector? Because if you have said so, then tribunal's order is wrong. If you have not said so, tribunal's order is not wrong. So therefore, we this is not your OA. Page 42 is not your OA.
Because annexed to the OA, this is annexure which was appended by the tribunal before the tribunal. So you can put it part of bidding. Tribunal.
Yes.
For the cat.
Yes. So you have been promoted with effect from 30th December 93. So there is a loss of 1 year.
Get promoted in 1991. Instead of that, it was in 1997. Not in 1990.
You are entitled in 91. Come to page 34. Read para 4. When I said 92, you said 91.
Seeing the
Then please, sir, don't do this. Yes.
promoted to the
We said 1 year, there is a loss of 1 year. Instead of 92, you have been granted with effect from 30th December 93.
I am not receiving.
Now you read 5. Next paragraph. The very next paragraph after 4. For that the applicant promotion to the post of sub-inspector with effect from 30/12/93. Again you are saying no.
What is referring to?
Page 34. Page
Yes,
34,
yes,
sub-para 5.
Ground five.
Ground 5.
The unfortunate part is that this post was never earmarked for SC. This was a general category.
That is immaterial. He says 6 years is the requisite experience. He completed 6 years in December 91. Immediately thereafter, he was required to be placed in January 92. Instead of January 92, he has been placed in that post in December 93. You say prior to that, there was no vacancy. We have asked him where was the vacancy on which you could.
At paragraph however, the applicant also has had there been a rank of sub-inspector in time. It automatically gives other graduate senior finally promoted to the rank of retired on in 1997, and just following his retirement on the that is on 1/5/1997. This one condo, that is the petitioner. The petitioner was promoted to the rank of sub-inspector in BPR and ND in 1997. Probably I am not.
Order issued in 97 does not mean promotion of 97. Order is with effect from a retrospective date. Huh?
Retrospective date, my lord.
What? No. He is correct. It is a retrospective date. Just now we have read in your own pleading from your ground.
It was given from 95.
It is retrospective.
December 95.
Correct. It is retrospective. Yes, we have seen in the tribunal's order, it has been recorded 30/12/95.
Yes.
In the ground, he has mentioned 30/12/93. But the issue is admitted that it is with effect from 95, not 97.
And another point, my lord, that he is not referring to your lordship, that we have annexed in the opposition page 64, my lord, the Bhuleram, who got the job, that promotional job. Yes, my lord, yes. On 2011, my lord, he retired as Deputy Superintendent of Police. He didn't even after retirement and during that post, which he got on 97, he did not choose to contest. He filed the application before the Honorable Tribunal on 2014. After retirement, much after retirement, 3 years.
My lord, that is not relevant in this case, my lord. My lord, kindly sees. Because my lord, they have not taken this quite earlier occasion or before the first round of my lord application filed before this honorable court, my lord. Before that, and the this honorable court was pleased to revert back this matter, my lord, to the learned cat. And thereafter, this order has come, my lord.
This court has considered anything in that order.
My lord, considering
You approach a writ court for a service dispute, then obviously it will say go to the tribunal.
not for that, this court interfered with the decision of the cat, and thereafter it was reverted to the cat for fresh
This
consideration.
is the second round.
Yes, my lord.
Where is the first order?
My lord, can't you see?
That you have suppressed from the tribunal. Yes, sir.
That was communicated to the tribunal, and thereafter
Where show us?
I shall, my lord, take some time.
Therefore, we asked you to show because you have suppressed that. You say that earlier there was an order, but you have never shown it to the tribunal. And the tribunal has held that you are guilty of suppression of a relevant and material fact.
Tribunal said that I did not show that, my lord, order.
Come to the last paragraph of the tribunal.
That is denied in.
Oh, please read, sir.
My lord, I'm again reading.
Last paragraph impugned.
Paragraph 13. In view of the above and considering all the facts and circumstances, we are of the view that in absence of any recruitment rules giving benefit of reservation in promotion to the post of sub-inspector, the applicant would not be entitled to get advantage of reservation in the promotion for the post of sub-inspector. Moreover, in view of the apex code, that the applicant cannot claim benefit of reservation in promotion. The applicant, by merely completing the eligibility criteria for the post of sub-inspector, cannot be given promotion without showing that a post was available for promotion on such and such date. The applicant has not come with a clean and guilty of suppression of material facts, and hence he is not entitled to get. Well, what is the brief, specific, what I have suppressed? Nothing has been stated.
That has been said.
That should have been.
We are not required to point out everything. We expect that you have read it. It has been said in the very same order what you have suppressed. Now we'll show you. Come to that. Don't say these things. Everything has been noted by the tribunal. The tribunal said that you have referred to some earlier order passed by the tribunal, but you have not placed it on record.
But that is,
the tribunal has said so. Don't say it has not been said. It has been, everything has been discussed. Therefore, we ask you, show from the tribunal's pleading where you have said about the earlier OA. Show us.
Yes, Malad, kindly, Malad, so far the date of giving effect to the promotion, Malad.
Where is the reference to the earlier OA? Show us from the tribunal's pleading OA.
Whether your lordship is pointing out the OA number 1096 of 1993.
You know, it is your case.
That has been, my lord, appended in my this application, my lord. That is the instant application. What was the order passed in 1997, and it has been admitted by the respondents that that order was passed by the principal bench of CAT. And after pursuant to that order, my reversion was, my lord.
Where is reference to that order in your OA?
My lord, at page 5, my lord, if I am not incorrect, my lord,
at page 5.
And that OA was filed for what? For promotion of sub-inspector. Then
That was, my lord, I challenged the order whereby I was, my lord, reverted back to the post of constable.
no, sir. You say you have filed an OA for promotion as DSP in 2011.
Yes, I have never said, my lord.
My lord, my lord, so far, page 5 is concerned that he has challenged for the post of head constable. Your lordship,
2011 OA.
yes, that is a separate matter.
Yes.
My lord, your lordship is considering the matter of for the post of sub-inspector.
Yes.
Now, admittedly, my lord, when he is complaining of the vacancy on, my lord, February, sometimes in February 1992, that time Kaluram, his predecessor, my lord, was in the post, so there was no vacancy.
Bhalera.
No, that time was January. Kaluram. Thereafter, my lord, if your lordship kindly take the page once, 64 of my affidavit in opposition. My lord, that's the second man in criteria, Bholeram. Bholeram, my lord, filed an application before the Central Administrative Tribunal at Delhi. There, he is not made a party to the petitioner.
I was not made party.
Even petitioner did not challenge the order before the Honorable Delhi High Court. So that order is binding upon the respondents. Page 64, your lordship, may I Constable, your lordship, got my lord, affidavit in opposition.
Just a minute.
Sir.
This is Bhaleram's case.
Yes, and my lord, you honorable tribunal directly consider the case of Choteram, that is 65, and we have to give effect to that order. So Bholeram, after retirement, my lord, when the Kaluram was, my lord, promoted, the post remained vacant, and the next candidate was Bholeram, and we give Bholeram, my lord, the promotional post of sub-inspector. So there is no, my lord, ill treatment or any.
No, so the whole thing is whether in 92 when he claims,
Yes.
he has stated that there was any vacancy or not. That is the only issue. Therefore, we have asked him.
Single post that is also not marked for SC, as he stated, that is a general, and that time Kaluram was in the post.
My lord, I'm trying to, my lord, there is probably faint indication, my lord, at page 7 of my this application, my lord. That is the tribunal application at page, my lord, at page 7. I have challenged Sri Kaluram being not shown as SC, but showing him as deputationist was irregularly absorbed in the vacant post of sub-inspector. Hereby, I am
In 2002. Then when?
Kaluram was.
When? The issue is 92 whether vacancy was available. Don't read such things which are irrelevant.
No, my lord.
We want you to show where you have said that in 92 vacancy was available.
That is the in which, my lord, Kaluram was, my lord, given promotion.
We don't know. That doesn't say 92. Therefore, he said when? 2002 or 2012? What is the date?
When Kaluram was given.
When?
Yes, sir.
When?
My lord, they have stated in their opposition.
Forget about what they have said. You have to make out your own case. It is not for them to
Kaluram
make out.
was given a, my lord, promotion. Kindly see, my lord, their opposition. My lord, I'm kindly give me some time, my lord. My lord, kindly sees their opposition at page 10, paragraph 2. The said Kaluram was promoted to the rank of inspector in BPRD with effect from 23rd November 1992.
Correct.
So they have stated here.
So there was, after he was promoted, so how there is a vacancy if somebody is already promoted there?
So I was entitled before him, my lord. That is my case, my lord. That he was, my lord, illegally promoted to the post of sub-inspector, depriving the petitioner, my lord. That is my case. And also I have stated at, my lord, page 7, my lord, that he was illegally promoted to the post of sub-inspector, depriving the petitioner, my lord.
This is the faint indication that I had stated that there was a vacancy, my lord. That is my case, my lord. Kindly.
You are referring to which?
Page 7, my
No, from the opposition, which paragraph you are referring?
Page 10.
Page 10, my lord.
My lord, that is in
second
the
paragraph.
post of inspector, my lord,
My lord, page
inspector,
10 of
not sub-inspector.
paragraph second, my lord.
My lord, he is incorrect. He is challenging for the post of sub-inspector. He is referring to the post of
Sorry.
inspector. Keep confusing.
Sorry. The said Kalun was promoted to the rank of inspector BPRD in 23rd.
That is inspector, not sub-inspector.
Sorry.
And therefore, after 2311, it became vacant.
Immediately, Bhole Ram was granted. He was in the next zone of consideration.
And my lord, another case is my lord, that he was the assistant sub-inspector.
So Balaram was senior, therefore he was promoted.
My lord, my case is also Kaluram was my lord the assistant.
Thereafter, just following his retirement,
Bhole Ram.
he has been
And
promoted.
immediately following the retirement of Bhole Ram, my lord, to the next provincial post, the petitioner was granted in 97 and notional benefits was given to him from November 95. As my lord fell from your
My
lord.
lord, my case is this, my lord. Kaluram was assistant sub-inspector. Thereafter, he was given the promotion to the post of sub-inspector. There is no, my lord, scope of promotion from assistant sub-inspector to sub-inspector in this organization. That was also my case, my lord. They are saying that the Kaluram was assistant sub-inspector and therefrom he was promoted to the post of sub-inspector. But my feeling is this, my lord, there is no scope from, but there is
Where they have said that he was a sub-inspector, assistant sub-inspector.
Page 10, my lord, page 10.
Yes.
Page 10 of the opposition, my lord. My lord, I'm reading from my lord, page 10. Concern, it is submitted that Sri Kaluram was from such and such, came to BPRD on deputation on 1970 and was appointed at the rank of head constable with effect from 6/1/1997 on ad hoc basis. He was promoted to the post of assistant sub-inspector, storekeeper, my lord. Ad hoc basis on 25/1/1984. Thereafter, Sri Kaluram was appointed in the rank of sub-inspector. There is no scope of
On deputation.
deputation. Yes, my lord,
Yes.
deputation. So he was not, my lord, absorbed. He was on deputation, my lord. So I have, my lord, I have the, my lord, I have the, my lord.
In your OA, you have implemented Kaluram as a party.
No, my lord. I have not my lord, implemented him as party.
Then how you can get the relief? If somebody is posted rightly, wrongly, whatever. Unless he is implemented, how can you get the
He
relief?
has also not implemented me in the party.
So therefore, two wrongs make one right. Wonderful submission.
But my lord,
We'll take note of this submission.
that covers my case also. If he did not.
That's not the issue. The issue is you want a relief, you are before us. He is not before us. Can you get a relief behind his back?
But my lord, their case is this, that there was no vacancy, my lord. This is their.
Now you jump from this point to that point.
I'm also,
You keep doing this all day.
I'm taking also that point, my lord. I'm not.
How can you? Therefore, we are asking you. If somebody is on a post, you say he is wrongly there. Therefore, you need not implicate him as a party and relief can be granted to you.
That I'm not supporting what, my lord?
What do you mean not supporting? You have said so.
But my lord, what they have taken the stand.
Therefore, the only issue is whether vacancy was there or not. There is no issue of Kaleram and Boleram.
That not also implicated Bhole Ram also.
Nobody, we have seen, that's why we are asking him.
And so far, my lord, so far, my lord, kindly consider another issue is, my lord. My lord, they have given me the notional benefit, not the, my lord, the actual benefit. Kindly see the, my lord, impugned order. Only once, my lord, at page 3, internal page 3. Kindly see that he is paying the scale of sub-inspector will be fixed notionally with effect from 30/12/95. Actual benefit, my lord, and shall, however, actually with effect from the date of issue of this order. That is from 1997, not from 1995. My lord, kindly consider this aspect of at page 3 of the impugned order. That is the order portion. Paragraph 2. Actual benefit was given from 1997, not from 1995.
Paragraph?
Order, last, second paragraph, that is the order in capital order, page 3 of the impugned order. That is running to 3. R.K. Mondal, your lordship got it. R.K. Mondal, constable is promoted as sub-inspector in the Bureau of Police Research and Development, New Delhi, with effect from 30th December 1995 in an officiating capacity in the pay scale of such and such. His pay in the scale of sub-inspector will be fixed notionally with effect from 1995. Actual benefits shall, however, accrue with effect from the date of issue of this order, that is 1997, not from 1995.
Yes.
That is to be, my lord, rectified.
Why?
Because, my lord, they have given it from 1997, not from 1995.
So therefore, what is wrong? You have to tell us.
Yes, my lord. As they have, my lord, given my promotion from the date of 1995, I am, my lord, entitled to get all the benefits. That is, my lord, salary benefit or others benefit, my lord, from the date of, my lord, 1995, not from 1997. That is my prayer.
Why he has been deprived of that period?
He has already got everything, my lord. Notional benefit is also, my lord, he got. My lord,
Notional means nothing. Notional means only that he will be considered as a sub-inspector. But he is not getting the, please, he is not getting the benefits attached to the post. Why he should not be? If you have given it belated, then why he should be deprived?
my lord, after the order of the, my lord, next promotional post of, my lord, Bholera, my lord, in 97, we observed him in that post.
Which post?
My lord, sub-inspector. He was promoted. He was promoted on 1597. Mr. Mondal, the petitioner hearing. And he.
No, why 1597? That's what we are asking. Go through it. You go through it once.
Yes.
We'll consider on Friday.
Very
List under, for further submissions, list under the.
আছে অ্যাপিয়ারেন্স আছে অলরেডি
আগে আছে তো ঠিক আছে পিকে মুন্সি
ও না না পিয়ার ভকত পিকে মুন্সি আছে ঈশ্বরঞ্জন ভকত
ঈশ্বর ভগত হ্যাঁ হ্যাঁ ঠিক আছে
হ্যাঁ পার
Yeah, that. And only the so both of them can be deprived or both of them will get maybe whether he has already got for school. How the person get the options for the symptoms.
Alert led by Mr. Vikas Ranjan Bhattacharya.
Yes, he is here.
আগের court order
Is for the state.
I think Mr. Tapan Mukherjee probably once appeared.
Yes, his name is appearing.
আমরা আগের দিন অর্ডার কোথায় আমার বিলটা কোথায়
He is not here, let us, we can return it for that day.
since he is not here let it be adjourned. What can be done?
Not today is.
Like, but it may order.
Yes, call the next. 15. That case. So calculate. Think.
In this matter, my lord, kindly remember this is that matter of S.K. Murthy's case relied by the tribunal.
Yes.
And my lord, here my lord, ASG is appearing on behalf of the my lord department. Though I am ready with the matter, but since ASG has been my lord engaged, so my lord, if your lordship is kindly fixed my lord on Friday, my lord, today my lord he could not come.
This Friday may not be possible.
Then my lord, next Tuesday if it's possible.
What is the date on next Tuesday? 11th.
My lord, 4th, my lord.
Instead of 4th, can it be on 6th? 6th or 7th? Then we'll keep it.
6th, 5th or 6th, as your lordship.
5th is holiday, sir.
Oh, very well. Then my lord, 6th, my lord.
6th. Week after that. The week after that. 10, 11, 12, whatever date. 11, 12, whatever date.
11 and 12. 12 तारीख
11.
12 my lord.
12. As paid list on 12.
Matter, Your Lordship, I am appearing for the petitioner, applicant before the learned tribunal below. And after exhausting my remedy in an original application as well as the review application, once I did not get the equitable relief pilot, I constrained to file the writ petition. The snippets of the fact is valid. Though I worked for the promotional post for the substantial period, but at the time of pay fixation, it has been reduced. So, the impugned order, Your Lordship, is at page 191.
191.
And the review mallet, without going into the merit of the review application, that is also annexed at page 1 mallet. It's the last annex. You'll have to read then.
The writ has been filed against the review only.
No, no. I have challenged that particular impugned order of the original application as well as the review order. Both.
What is the date of the original order?
That is valid 27th March 2018 at page 191. And the review order valid, it's 13/6/2023. At least valid after the pendency of the 5 year due to non.
রাজীব আগেরটা কিনা বেঁচে গেল সেটা বলছে না। আপনি গেছে এই টাইপে যাচ্ছে।
Yes.
Going into the record ballot, I'm pat on the point that the RB 48 of 2006 is pertinent and the FR rule that has been quoted is pertinent. Now, your lordship, kindly go to page 196 in order to reiterate the for RB 48 of 26 under which they have to be taken into consideration.
Yes.
I'm reading, your lordship. To arrive at this conclusion, the respondent authorities have relied on RB 48 of 2006 as communicated such and such. What is the subject matter? Admissibility of pay, oblique stipend and PLB, etc. in service candidate undergoing apprentice training on the railways. After ballot, if your lordship will go to next page, that is last 2B. In 98-97, I'm referring para 2B. In service candidate appointed as apprentices against the earmarked quota for them with inter-apprenticeship but not covered by C below will be treated as railway servant on duty and will be governed by the provisions of Rule 1311. During such training apprenticeship, they will eligible for all the allowances and the privileges, including TA, DA and PLB on the basis of the substantive cadre of pay post held before being sent on training as per the provisions of relevant rule. So this particular circular is talking about the allowances and privileges, not the pay. Now,
What is the date of your substantive promotion on the post of permanent way supervisor?
That is 1/5/2006.
Let us see that order. 1/5/2006.
I'll look up to page 55.
50?
5. Such and such ballot dated 1/5. Provisional panel of selection for the post
So
of.
this is not there. Again, we are asking, what is the date of the substantive appointment order to the post of permanent way supervisor, which says you are hereby appointed, go and join. Because prior to that, you cannot claim any benefit for that post.
If your lordship will read page 57 and 58 go jointly, then the inference which your lordship intend to will get it. That is line training for the post of supervisor PUA.
No, this is not. This is you are found suitable for the post and are booked for training. We are asking you again the date of substantive order, an order substantively appointing you to the post, the promotional post, the benefits of which you seek. It is a settled law that until you assume the duties of the promoted post, you cannot get any benefits, whether RBE or no RBE.
Here I joined the issue. I spared for the promotional post. I was performing for the promotional post, but so far as the.
How can you unless you are appointed?
Yes, that is.
Therefore, we are saying, where is the appointment?
Yes, kindly come to page 60. 50 onwards ballot. These are the correspondence ballot.
No. These are correspondence. Yes.
So far as that particular question ballot, it can be inferred from the subsequent pages.
No, there has to be an order that you are hereby appointed as permanent way supervisor at such and such location. You go and join that post. Where is that order? This is finding you suitable for the post. This is sending you for training for the post. This is not an appointment to the post.
Well, that answer, Mallet, is my service certificate.
Service certificate?
At page 61.
Page?
61. 61. Here, Mallet, my last pay was drawn 12,220 at PB such and such, and the post mallet which I have been designated, that is PWS.
Has to be because this is of 2009. You want it with effect from June 2006.
When I released for my online inline training.
Therefore, we are asking you whether you can get the emoluments prior to joining on the post. That's the only issue, RBE or no RBE. The law is very well settled. A promotional post benefits can be claimed only from the date you assume the promotional post, not prior thereto.
I have rendered my service that
We don't see anything. You are saying so.
but they have sent me the specific training after the completion of 19 months when I performed to that particular duty, and they have sent me for the training after.
So you want only for that 19 months.
Then after my I retired. I retired in a.
How can you retire? You say you have worked on 19 months, then you were sent for training, then a substantive appointment was issued to you. So those 19 months you worked without making any claim. Thereafter you were sent for inline training.
I was getting the salary of the promotional post.
You may have, that is why they have adjusted it, because you wrongly got it. That day you are not qualified. You had not completed the training, you had not acquired the requisite qualification.
Need to be sent by the department itself. I have been produced myself for that particular training, and they sent me.
The fact remains you were not trained, you were lacking in requisite qualification for the post. You performed your duties for 19 months. You got the benefit for that also. Thereafter, you were sent for the training. After training, an order was issued substantively appointing you as a permanent wage supervisor. From that day, you were placed in the scale of 5,000, whatever it is, pay band of 5,000, so and so to 22,000. While fixing your pay, that was in the 5th CPC. Then the replacement scale was granted for 6th CPC. While fixing the replacement scale, in the 6th CPC, they have adjusted that emolument paid to you for 19 months.
Either invoking 48, RB 48.
Invoking whatever.
But RB 48.
So therefore, again, we are asking you, is the issue only with respect to those 19 months? Or is the issue that you want it continuously and that the same shall be continued while you were in training and everything?
So far as your lordship query, so far as the PWM, Permanent Way Mistri, I joined on 1/5/2006. Then after performing for that post in 19 months, I sent to the training to Buli Dhanbad. Then after my lord, I got the salary and I retired on 30 September 2009. So from 1/5/2006 to 30/9/2009, I worked for the post of PWS.
You did not. While you were training, you did not work.
In that way, if they have spared me for the
No,
training,
you cannot say that you worked. You were undergoing training. How can you work? It is as clear as daylight. There can be no dispute about this.
That particular question, lordship, this answer to that your lordship query is not only one paper. When your lordship will peruse the series of the paper and the correspondence between, then your lordship may draw the inferences.
We are
that where is that particular where you have appointed substantively?
No, because the tribunal has taken note of that order. The tribunal has considered the date on which you have substantively been appointed.
Go to their speaking order. What the speaking order they have stated?
Whatever they say, we are here to decide the issue or see whether the decision is proper. They may have taken a stand, you may have taken a stand. The issue is you rose from the ranks right from the post of gangman. You came up to the post of permanent way supervisor.
Mistri, PW.
Huh?
PWM, Permanent Way Mistri.
Not supervisor.
Not supervisor, PWM.
Only Mistri. Are you sure?
That is written.
It says stroke. So which one it is, we don't know. PWM stroke PWS.
No, Malad. Here, Malad, the Permanent Way Mistri.
Mistri, yes. So you were posted on that post on 1/7/2006. That is your claim.
Yes.
They say that you were sent on training. Inline training was completed. and finally your appointment was done on a particular date, and from that date all the benefits have been given to you. Prior to that appointment, whether you can get the benefit or not, that is the only issue. Now, by virtue of discharging duties, you have taken that emolument which they have adjusted. So therefore, we are asking you, there is a no continuity either from their pleading or from your pleading. There is one period prior to training and there is one period post training. So there is a break in between. It is not continuous. For the period prior to training, you have received the emoluments which have been adjusted later. For the period after training, you have been given the payment. So for training period, you cannot claim. Therefore, the issue is only of 19 months.
That case, valid the 40, because they are deciding my case on the basis of the RB 48.
We have said at the outset, forget about RB.
That case, valid, then
If there is any provision under which a person who may be wrongly appointed to a post without even possessing the requisite qualification, he is entitled to the emoluments of the post, show us. Then RB 48 means nothing.
I have performed for the higher responsibility for the substantial period. And that is the pay pursuant to the higher responsibility, I have got it. And the training which they ought to send me within the tenure, they put me 19 months installed. They have not sent me for 19 months and they have allowed me to work for the high responsibility mallet. In that case, what would be my position? So for the
Correctly, that is the correct, that is the situation. Because their mistake will not vest a right in you.
Now, in order to justify their mistake mallet, they are taking the plea of the RB 99. Sorry,
again and again you are harping or RB 48.
I'm specific reading in the ground. I have taken my lot on that.
The point is, the only point is, for anybody's mistake, a person who does not possess the requisite qualification, how can he get emoluments for 19 months? Otherwise, if it is to be accepted, then tomorrow it will open a gate for arbitrariness. Anyone can pick up anyone and say, go and you work. No, you will get the emoluments anyway, whether you are qualified or not.
That is why the Lordship may ask department also that what prompted them not to send me 19 months for the training period.
The issue was never taken up by you. They sent you, you went. And you could have taken up that. Why you are not sending me for the training? It's not raked up by you. There's no question of going into it now. Because after working for 19 months, you have gone for the training. You know that the training is required, otherwise you cannot. So even if we take it that by mistake or for any reason they have posted you for 19 months, can you legitimately claim a benefit of the post? It is a different thing whether it can be withdrawn or not, whether rightly, wrongly given. That would be a different issue. But then again, it would be confined to those 19 months. Because after that, there is a break which is admitted.
That they are considering that I acquired the required education for that.
During that period, you have acquired.
My context is this palette because I was performing, I has released from my substantive post in order to mitigate the requirement of the online training. I have done everything and they sent me on training after completion of 9 months, which is not in my hand.
It is 9 or 19 months. 9 months or 19 months.
9. So if they have inducted me for that, if I become suitable mallet, now it is incumbent upon the respondent to send me for proper in order to acquire that particular service.
You cannot be suitable unless you acquire the qualification.
That particular mallet, that thing your lordship will go by the 57 onwards mallet.
Yes.
Kindly mallet, I have just 2 to 3 pages mallet. I bother you lordship to peruse. On being declared, just a minute.
Yes.
What was the first letter mallet? Just bear with me. Provisional panel for selection for the post of supervisor P-way in a scale of such and such against promotional quota in civil engineering department.
This is which page you are reading?
This is page 55.
Yes.
Here my name is appearing at serial number 2. So this is what the contention mallet. Provisional panel of selection for the post of supervisor P-way in such and such scale mallet. Designation, senior trackman, I was holding that post mallet. Then after your lordship, kindly go to next page. Here, they are declaring me as a medically fit. Medical fitness in A3 category on promotion supervisor P way in such and such a scale. Then after, my name is appearing serial number 2. Then your lordship, kindly come to page 57. On being declared medically fit in A3, the following senior trackmen in scale such and such, that is by substantive scale, who have been found suitable for the post of supervisor P way in a scale of such and such, by this office letter of even number dated 1/5/2006, are booked for line training at the place noted against each. I have spared. My name is appearing in serial number 2. Now come to page 58, your lordship. This is the departmental letter under which the line training for the post of supervisor in a scale of such and such, as per above order of Sri Hemacharan Mandal, take such and such under P way, Jasidi is hereby spared on from 3/6/2006. I spared for the promotional post ballot. The entire
For the
that is
page?
That is page 58. 38/6/2006 afternoon, and directed to report further duty line training under
Correct, for training. Yes.
for the post of
Training for that post. Correct. Correct.
for the post of
Permanent way, Mr.
permanent basis, the scale of such and such.
Yes. This is
Accordingly, my
for
lord, kindly
training.
go to page 60.
Yes.
I am in reference quoted, I am reporting myself as PWS in a scale of such and such on and from 1/7/2006 under your kind control. This I have tendered on 1/7/2006, means 1/7/2006 onwards, when they are sending me for online training, my lord, they are sending me on.
What is at page 58? They are directing you to go to which office?
I beg your pardon also.
At page 58,
Yes.
when they have asked you to go for training,
Yes.
they have asked you to go to which office? Line training for the post of supervisor. Spared on and from 36 and directed to report further
From Jasidi to Sitaram.
line training under
From Jasidi to Sitarampu. JE Sitaram.
JE?
Sitarampu.
Where is that?
Sitarampu adjacent to Asansol.
No, where is that mention of
Top from JE, from P-way.
Sitarampur? Yes, JE Sitaram.
So I said, and when they are sending me to Dhuli Mallet, they are sending me 2/4/2008 total after completion of 19 months, when I performed my duty towards the higher responsibility I performed. So they could have sent me at that point of time. Arranging a training is not a prerogative of a income. It is on administration to decide that to whom and when, but they cannot prejudice my rights to extent that due to, if that is the sine qua non for getting that post, then they ought to send me at that point of time.
You have never claimed that relief. You have never claimed that relief.
For the training ballot.
Yes.
Because well, at that point of time, it could not be inferred that due to this particular thing, my pay shall be reduced substantially.
How you got it? That is what is surprising. How it was granted to you? What basis? Show the order by which it was granted. How can you? How can you? A post which requires a particular qualification, a prerequisite, without that you will be paid for that post. Just because somebody picks you up and allows you to work.
Because they are harping they are hovering around that particular RB circular because they are guided
Not
by
concerned with RB.
that is guided by
They are not
and that particular circular itself says I shall not be entitled to get the substantive allowances and privileges of I shall be entitled only the
This is appointment of PWS is under which provision? That is that provision on record?
Full ballot I have to produce.
Then not required.
So that is the only thing I can produce ballot. That what are the conditions precedent to become a PWS?
No, that's not in dispute. That's not an issue arising for consideration. You know that it has to be, you know that you have to do it, you have done it. You could have said, why should I go on training? Not required, I will not go. You continue with this. You have not said that. You went for training. So therefore, that's not an issue. What is the date of your substantive appointment? Again, that date we have got somewhere just. One 11/2008.
Yes.
So that is the date on which you have taken charge of PWS. It's PWS, it is not PWM. In that joining which you have just shown, there also it is stated PWS at page 58.
Dispute is with regard to PWS, permanent way is 3. PWM, sorry, permanent way.
No, come to page 60.
60.
Yes, as a PWS, not PWM.
Yes, I'm saying PWS, permanent
way supervisor.
And while they are using this particular oblique, it is having the common meaning altogether. By deriving that particular PWS or PWM, they are using interchangeably.
No, but they are two different posts. In one case, we have seen it. They are actually two different posts.
And while I kindly come to the contention at page 200, what they are saying, that's the part of their speaking order. On record,
the speaking order is at which page?
The speaking order, my lord, that the part and parcel of the speaking order is also in verbatim submitted, my lord, that is at page 93. And that contention has taken by the learned tribunal as paid 200 euros. The inferences which has been drawn by the tribunal on the basis of the depiction of fact. October 2008, my lord, that office order was issued after completion of the training.
Yes, same date has been considered.
The question is this, my lord, if a person was in probation period for the period of 2 years, and after probation he qualified for the said permanent post, permanently appointed, whether for that particular probation period he would be entitled for it.
He will, there is no doubt, provided he is on probation. Provided he is on probation, not while he is in the academy acquiring training for joining. That period he will not get. Only after joining he starts probation.
My basic case, if
he
I
does not become on probation prior to joining.
Been selected, I have been declared medical fit, I have been spared, I tender my
for line training.
Yes.
In all the orders it is said
What
for
would be the
line
pay, my lord, at that point of time when I was performing the inline training?
Obviously the pay which you are getting,
if that
unless you can show that no, for this training period I must get a higher, you will not. That is not your case. That is not your case.
Case is this particular
What you are submitting is not your client's case. Your client's case is that I have got it, I must get it. RB 48 is not applicable. That is all that he is saying.
RB 48 is not applicable in the case because that is deals with the allowances and privileges.
Correct.
It is not the substantive because the pay deals with the
Whatever it is.
deals with the fundamental.
So therefore, still it remained for you to establish whether you could have got it prior to promotion.
Now the fulcrum, the concentrating,
date,
if I produce the recruitment rule of the PWS,
not required, not
then
required.
I would be in a
Not
better
required.
argument.
11/8/2000. Sorry, what is the date on your substantial appointment to the post?
That is 31st August 2008.
1/11/2008.
31/8/2008. And 1/11 I joined.
Yes, 1/11 you joined.
That is a page 200.
So prior to page,
Page 200.
that is what we are asking you.
I'm assisting Your Lordship in that matter. Kindly go to page 200, that the pertinent fact has been depicted here. On record, after found suitable in written test.
Where is the order,
That
sir?
is well at page 200. That's the part
That
of
is
the-
not,
the
huh?
part-
It is quoted there.
Yes, that order is in verbatim quoted.
11/8/2011 order.
Yes.
So this order of 11/8/2011.
Yes, sir. That is the declaration that I joined on 1/11/2008.
No, this is an order. This is an order.
That they have dealt in their reply, Malik. Sorry, speak the order.
We are looking for your joining order dated 1/11/2008.
That is not available, Malik, here.
No, it has to be. It has been taken note of by the tribunal. Where is 1/11/2008 order?
Seven
167.
is not the particular date. 10 to 12. Blood has been written. On completion of successful training.
That order is valid not.
On 11/8, order has been.
No, there is no order of 1/11. There is an order of 31/10/2008. Where is 31/10/2008? What do you mean? No, he must have annexed. Just see whether 31/10 is there.
No, Malik, it is not there.
Go through it. It must be.
Number 10.
Well, I appear for the petitioner. Well, in terms of your lordship's direction, my lord, I've asked my junior to hand over your lordship the matters. My lord, there are in all 6 matters, including this one, my lord, and the orders, my lord, are kept with my junior.
এটাতেই বোধহয় বলেছিল না ওই এই ম্যাটারটা
In one matter, my lord, Mr. Bishopio Bosu Mollik is appearing.
We didn't want this. Yes, this is what we want. It has been fixed for 18/11.
One is 2 are fixed on 18th, 2 are fixed on 12th. My lord, in one matter where Mr. Bishop Bosu Mollik is appearing, it is fixed on 12th. My lord, if your lordship takes up WPSC number 200, my lord, same issues were there. Mr. Bishop Bosu Mollik appeared, and my lord, it's fixed on 12th. This is the matter he was talking about in the morning, my lord.
Not only me, my lord, Mr. Amol Sen, Mr. Everyone is appearing. I had a talk with Mr. Sen also today, my lord. So, and because the problem is, my lord, that today is the state government is a holiday.
No, you are not required to talk to your colleague. You are required to.
No, not colleague. I have talked. Department is closed today. The office is closed because of the Chhath festival. And my lord, I had a talk with them, but it's not I have not talked with them, my lord. I specifically told them the views expressed by his lordship. And I specifically also told them to give me one write-up so that I can place it before his lordship that what is the predicament for you to pass the similar order in spite of the fact that the views of the High Court is otherwise. So they says, my lord, that they will file a report before it to me, my lord, so that I can place it to his lordship. And it can explain everything. And in terms of that, my lord, lordship, this is what, my lord, I have specifically told them, my lord, that the view of the court is not good at all, because the court expressed their opinion that this resignation you have to be accepted. This cannot be. But they says, my lord, there are certain conditions and all these things. That's what I'm saying, my lord, that give me in writing so that I can place it before his lordship, and accordingly, lordship will consider or proceed with these issues. Since the view of his lordship sits with Justice Tandon is, my lord, abundantly clear, wherein learned Advocate General is appearing. Thereafter, in these matters, my lord, his lordship has passed orders following that my lord, judgment that has been passed by his lordship. So
One important link in the chain of events is that in compliance of those orders, you have acted.
Absolutely.
Yes.
Then where is the occasion for again doing this?
That's what, my lord, I'm saying, my lord, that let them give some papers why they have not done it, in spite of the fact that the view of his lordship is abundantly clear. What they says is, my lord, I just recollect, my lord, that there are certain criteria with regard to my lord, the filing of resignations applications. There are certain criteria. Thereafter, certain amendment has been made in the notification, where it has been mentioned that medical ground is one of the important aspects, and that has to be considered by the documents and all. This is what, my lord, submitted to me. That's what I have specifically asked them, my lord, to give in writing, my lord, so that can be placed before his lordship, and lordship has incorporated in the order. ওই জন্যই তোমাকে কি বললাম, কাগজপত্র ছাড়া আমি কিচ্ছু এগোবো না।
So for the moment, what they stand is that there is something in the rule which gives them the
embargo for which, my lord, they are outrightly cannot allow them to resign, my lord. So
This
that's
was-
what I'm saying, my lord.
This has not been canvassed in the earlier writ petitions.
This is what I have I have specifically told the order passed by his lordship. They are well aware about these orders, but in spite of that, I told them that why you have passed same orders when the court's view is otherwise. So at that point of time, they said, my lord, with regard to notifications, there are certain pro forma with regard to, my lord, application for resignations. That's the problem, my lord. That's what I'm saying, my lord, that let me come up with all those documents before his lordship.
But subject lordship, kindly, if your lordship takes up the rejection order, my lord, it only says, my lord, there is a shortage of doctor. It never says of any rule. I don't know, my lord, the only rule is there, my lord, amendment is there with regard to doctors who have performed less than 5 years. My lord, 7 except there is no other option, according to me, my lord, subject lordship kind consideration.
Yes.
So the earliest matter is on 12th.
12th. So let not only one matter, but WPST 200 and then 203. Both these matter fixed on 12th.
12th.
And other matters, my lord,
On
there is a
18th.
direction. My lord,
Others are on 18th.
others is on 18th, my lord, wherein his lordship was directed to file affidavits. 18th, and another one is on 28th.
Last matter will be sent.
Wherein the state is not appear.
And these orders are passed at the secretary level.
Yes, my lord, in this case, secretary, my lord.
Those two matters are direct, supposed to appear on 12. So let this matter also be appear, my lord. So that at a time, my lord, Lordship will pass order. Let me see what they have said, my lord.
We will have to do something. We
Yes,
cannot
now
permit
this
this.
time, my lord, to do something. Otherwise, it cannot be, my lord.
Either
The order
you
of
have,
his lordship has been complied with. my lord.
either you do something or we will have to do
No,
something.
I will entirely leave it to his lordship. Let me go through the papers. Let me
Yes.
bring those papers.
And they may see the legal position judgment of the apex court also.
Yes. The problem is, my lord, the order of his lordship has been complied with.
Judgment of on two issues. One is whether a person can be forced to continue to work. That is decided in the case of Sanjay Jain case. Second thing, whether it is open to an authority to take such a stand repeatedly. And if so, what is to be done?
Repeatedly and
Complying,
the order of the
yes,
court.
selectively complying, and therefore. So both these issues,
Yes.
we are
Yes,
observing out loud so that you know that you will be confronted with these issues. So better that
I will.
you have a talk so that, yes.
Get
My lord, only thing, my lord, let the matter retain its position, my lord, as motion.
Yes, it will come along with that matter, those matters.
As well. Deep level, my lord.
I filed the affidavit of service also.
Affidavit of service taken on.
Deep level, my lord.
Continue matter item number 16.
Gill.
Lordship may kindly come to page
Yes, my lord.
32,
But
my
that particular date was wrongly mentioned, my lord. So I could not assist your lordship that point of time. 31/8/2008 it is written, but literally it is 31/10. Yes, that is here, my lord. Kindly come to page 114.
Which letter you wanted to show, my lord? That letter is 232, my lord. 1/11/8. Which date was your joined? 232, page number 232. Which letter you wanted to, your lordship wanted to see? 232, the Hema Charan Mandal, after completion of his training, he joined. Page number 232. Here the post and the reference under senior DPO, Asansol, letter number Asansol. Above, I have taken independent charges as PWS as posted under RC with effect of 13 sir, the scale 500, 5,000.
Salary was drawing on that scale, on that date.
But previously, another was the wrongly was sent.
Kindly come to page 114 first.
On the basis of this
He's
letter,
taking about my letter. Prior to that, they have issued one letter. In compliance of that letter, I am rendering my joining. Kindly go to page 114. What they are addressing. The 114, my lord, it is a letter issued by the senior DPO office in which it is categorically stated the competent authority has passed the following order to take immediate effect. The following supervisor PW in a scale of 4500 to 7000 in RSP PB2, that is corresponding to 5200 to 20,200, where the grade pay 2800, have been declared passed in the principal Zeratai Bhuli Dhanbad and found suitable for the post of supervisor PW. So we have treated supervisor PW, and after completion of this, we have been. Sorry, ma'am?
What is the date of your Viva Voce?
Viva Voce.
After a written exam, you are eligible. Is there any Viva Voce or there is no Viva Voce?
There was a Viva.
What are you submitting? How can you make such submission?
That is letter, my lord. That is their office order.
That is the letter which it means. It says what it means. It says you have been found suitable. That does not mean that you become eligible for holding the post.
What they are addressing me.
Prior to Viva Voce.
No, prior to that, I was senior trackman.
Yes.
Prior to this post, holding
Yes.
this post, I should be treated as a senior trackman.
Yes.
Unless I am successfully completing the
Correct,
training.
correct,
Very
correct.
good. If that is the training, mallet, if this is the letter, the following supervisor.
114 we cannot read.
I will supply the copy, mallet.
How are you reading, we wonder?
No, that is clear to your lordship, probably. The following supervisor PUA means 1, 2, 3, 4, 5, 6 are the holding the post of supervisor PUA in a scale of such and such, which I was required and I was getting, passed by in terms of the principle such and such, found suitable for the post of supervisor PUA. I am holding the post of supervisor PUA and I found suitable for the supervisor PUA.
That
Then
you know, that's not a mystery.
And
You know that you have been allowed to work on that
kindly,
without the qualification.
Only
That is an admitted position.
the only differentiation in this letter, ballot, they have.
Then you should not have gone for training. Why are you sending me for training? I'm already a PWA, whatever it is. You give my salary. You know everything. You can't derive any advantage from this situation. You know you have been posted without having the requisite qualification. Thereafter, you have acquired the requisite qualification. You have acquired the training. Then you have been posted and then you have requested for fixing of your pay in November 2006, 2008. You see what you have said in your joining. Come to page 232.
Kindly
Come to page 232.
Yes, mallet.
How can you know the situation? Come to page
Here
232.
my specific instruction I have taken from
Yes.
my client, and I could do any extent in order to ascertain the validity of this letter. And kindly go to my next reply mallet, where I have stated rejoinder.
What do you mean validity? Who is denying the validity of this letter?
No, they are saying this letter has been authored by me. I am saying that I am not been. This letter is not been authored.
Which
by me.
letter?
They are 115, your lordship.
114 you said, now you're saying.
114 is the official letter and 115 is my letter, which they are saying that I have, because they are taking the approbate and reprobate. Because once I have accepted 110/2008, so therefore I cannot take that plea. But my plea is that this particular letter is not being authored by me.
Is it open to you to
Yes.
take such a plea today?
No, that plea has taken.
Once you have signed it, you can say not authored by me. Wonderful. Then signing means nothing.
Because this is not my signature, mallet. I have stated so. I have stated so in my reply. I am showing you, lordship. Kindly go. Whether the existence of this letter has been admitted by me or not. Kindly go to rejoinder mallet, page 134. Because what they did, they have produced this document in mode of R1 and R2. But in their reply, they have not specifically dealt this letter in any paragraph. But here, mallet, in page 134, you will also get para 8, that the statement and rubric allegation made in paragraph 10 of the said reply are all wrong, bogus, motivated, misconceived, and misleading, with twisting of the actual fact, and hence those are categorically and emphatically denied in view of the admitted fact that the applicant took charge of PWS on 1/7/2006, but not on 1/11/2008 as alleged. Now read 114, your lordship. This particular senior DPO office has designated me as PW, supervisor PW.
See the signature here. Same signature.
And the signature is not at all matching. Because there are several signatures are there, mallet. My representation is there. It is completely concocted, mallet. I'm disputing the fact.
So where is your joining? Show us. If this is not your joining, where is your joining? Show us.
That particular joining is mallet. I'm showing. Page 60. Page 60.
This is not your joining. This is not your joining. This is what you claim should be the date from which you will get the benefit. This is your claim that I must get benefit from this date. This is not your joining. We asked you, where is your joining after training?
That is after training from Huli, my lord.
Where is your joining?
No, that I have not rendered, my lord. That joining report is not with me, my lord.
So you have not joined after training.
So that is because this particular dispute
Which
came
date? Where have you said in the OA after training? When did you join? Show us.
in OA, my lord.
The same. Like this.
Kindly come to page 37, para C. The applicant states that after getting promotion to the post of PWS on 1/7/2006 and joining in that post on 1/7/2006,
Again, we are asking you after training, what happened? According to you, what have you stated in the OA? What happened after training? Tell us.
after training, my lord, my cause of
Well, where is your averment regarding training in the OA?
kindly come to page para 37C. Then after I'm looking, my lord, I'm telling you. Page 37, yes, para C. The paragraph is also there, valid. The seeking redressal of legitimate grievances, the applicant has representation to the authorities on 9/6/2009, along with the memo dated for 27/4/2009 to senior DPO, clearly narrating thereby to remove the anomaly in wrongly fixed pay scale, but no one. So these are the valid things.
Again, we are asking you.
I understood you, lordship.
You have gone on training.
I have gone on training.
When have you joined after training? What have you said in the OA?
My case is this, valid.
Where is your case? That
My
is
case
what we want to
see.
Please read it.
The applicant states that
After training.
getting promotion to the post
After training, again and again we are asking.
that averment is not there.
You have said nothing.
I am saying
You have said nothing.
lordship is asking 1/10/2008 what happened, what I have stated.
An order has been issued. 3110 an order has been issued.
Yes.
What have you said about that order in your OA?
3110 order was issued and
Where is it? Read it, please. Don't make submission. We want to see the petitioner's stand. Since he is taking such a stand, therefore we are asking. He is alleging that some railway authority has forced his signature and given a letter.
Kindly come to page 134 of my rejoinder, because these are the production.
No, come to your OA.
Oh, I cannot, because that particular production of record in reply. So therefore I rebutted in my rejoinder.
So in your OA, we are asking you what you have said about training. Where is that paragraph? Show us. See how anybody can do.
Yes.
How do you file these cases? Really, it is surprising. Nobody bothers to see anything. Your pleadings are illegible. Your documents annexures are illegible. And you are reading as if only your reading makes a difference in a court proceeding.
The best available record value provided by my client to me, my lord.
No, because you are reading it. You must be having a more legible copy.
Yes. In comparison to your lordship, then I can supply the
Then please don't say such things.
my effort is to enlighten your lordship.
You cannot. How can anybody read this? You tell us.
Then, my lord, I will supply you. If that is the condition, my lord, because that particular is being filed.
You should be knowing you have filed it. What is the condition? You should be knowing. It should not come as a surprise to you.
I overlooked, my lord. Tender my apology for that.
And just now you are referring to that letter. Nobody can read that. You see, where is that letter?
114, your lordship.
Yes, just please see. You read one word from this document.
I did say that. Yes, I will supply.
Wastage of time.
So the content, my lord.
What content?
Because
Then
since
don't
you
file
did not
anything.
ascertain, my
Then
lord,
don't file anything.
and there is no dispute at all. There is no dispute. There is no type of it.
So much of time unnecessarily, it is wasted. Let the learned counsel for the petitioner file a paper book.
That I need to supply the all. Can you fix a date, my lord, in that case?
Yes, we have said after 1 week.
On 6th, I have some predicament, my lord, because the circuit bench matter is fixed in Andaman, my lord. Any day thereafter.
Yes, so?
I'm praying your lordship any date thereafter.
So we are asking you which date?
Let it be 11th, my lord. 6th is a Thursday, my lord, any Monday thereafter.
11th or 8th, 18th. 11th we cannot have it. None appears for the writ petitioner. For the petitioner or respondents, both. None appears for the writ petitioner or the respondent.
Similar matter.
19 to 24. Hmm? Not today. Not today. In 18 also, don't write the order, just not today.
And 25. 26.
26, I am for the respondent.
Call the next.
27. 28. 29. 30. 31. 32. 33. 34. 35.
So I'm waiting for the respondents in the matter. Lordship, the petitioners, kindly look at I'm aware about the resolution, but kindly look at the last orders, the petitioner not appearing in the matter.
Call the next. Yes.
36. 37. 38. 39. 42. 43. 44.
Yes. You are for? All right. Call.
45. 46. 47. 48. 49. 50. 52. 53. 54. 55. 57. 58. 59. 60.
My lord, I am for the petitioner in 60, my lord.
Yes.
I am not with the brief, my lord.
Not today.
61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 78. 79. 80. 81. 82. 83 and 84. 85. 86.
87, 88, 89 and 90, 91, 92, 93, 94, not 95, 96, 97, 98, 99, 100, 101, 103, 104, 105, 106 and 107, 109, oh, 109 is not clear, sorry, 110, 111, 112, and 13, 114, 115, 116, 117, 118, 119, 120, 122, 123, 124, 125, 126, 127 and 28, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141, 142, 143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, আস্তে কল করতে ভুলেছি, জোরে কল করছি, 157, 158, 159, 160, 161, 162, 163,
I'm for the respondent is
164, 165, 166, 167, 168, 169, 170, 171, 172, 173, 174, 175, 176, 177, 178 and 79, 181, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205 and 6, 207, 208, 209 and 10, 211, 212, 213, 214, 215, 216, 217, 218, 219, 220, 221, 222, 223, 224, 225, 226, 227, 229, 230, 231, 232, 233, 234.
That was for the respondent in item number 174.
You're writing?